Imagine your business operations suddenly face an unforeseen challenge, something completely out of your control, like a natural disaster or a global event. Reviewing force majeure clauses in agreements means carefully examining the contract language that defines and addresses these extraordinary, unavoidable events, determining when they excuse a party from fulfilling their contractual obligations. The core reason these clauses exist is to allocate risk fairly between parties when performance becomes impossible or commercially impracticable due to events beyond anyone's reasonable control. Without a clear force majeure clause, one party might be unfairly held liable for a breach of contract, even in circumstances they could not prevent. When you are reviewing a force majeure clause, begin by looking for a clear definition of what constitutes a force majeure event. Is the list exhaustive, meaning only listed events apply, or is it illustrative, allowing for similar enlisted events? Pay close attention to notice requirements. Most clauses requiring prompt written notification to the other party when a force majeure event occurs, specifying its nature and estimated duration. Next, examine the impact threshold. Does the event need to make performance impossible or merely commercially impracticable or cause significant delay? Understand the consequences. Does the clause simply suspend performance for a period, or does it allow for termination of the agreement if the event persists beyond a certain timeframe? Finally, check for any mitigation requirements. Does the impacted party have an obligation to take reasonable steps to minimize the effect of the event, even if they are excused from full performance? A crucial insider tip is to specifically check for what are called carve-outs or exclusions. Sometimes, even if a general force majeure event occurs, the clause might explicitly state that certain obligations, like payment obligations, are not excused. Furthermore, remember that the legal interpretation of unforeseeable or beyond reasonable control can vary greatly depending on jurisdiction and the specific wording of the clause. For example, a pandemic might be considered force majeure after 2020, but what about future, similar outbreaks? Thoroughly reviewing force majeure clauses ensures your business understands its rights and obligations when the unexpected happens, providing a vital layer of protection. This proactive approach helps mitigate financial and operational risks, ensuring your agreements remain resilient even in the face of truly unavoidable disruptions, and allows you to focus on adapting rather than litigating.